Okay. Good afternoon, everyone. My name is Karaman Hassan. Welcome to our webinar series. And this series is a part of activity of Environment, Energy, and Natural Resource Center at University of Houston Center. We try to select the topics of the days and the discussion of legal issues that we have in the country, and we're trying to invite our best legal minds in the country to this activity. So today's webinar, our co-director, Professor Gina Warren, will join me to moderate this webinar. And so for today, Professor David Adelman is talking about a very interesting topic, which is uh, permitting reformers false choice. So Professor Adelman has been a faculty member at the University of Texas School of Law since 2009. His research focuses on environmental litigation, policy implementation, and limits of science in regulatory decision-making. His work has been widely published by our major law review journals, including Harvard Environmental Law Review, Texas Law Review, and has been recognized by the Environmental Law Institute and the Land Law and Environmental Law Review. So before academia, Professor Adelman practiced law in the Washington, D.C., and handling environmental regulatory matters, and served as a senior attorney with the Natural Resource Defense Council. He clerked for Judge Samuel County in the U.S. District Court in California. He also holding interdisciplinary background in chemistry and bachelor in chemistry and physics from Reed College, and also PhD in chemistry with a JD from Stanford Law School. So for today, he's discussing the permitting reforms, false choice, as push of renewable energy acceleration and environmental laws. Many people arguing that our legislation, including NEPA, ESA, and also Clean Water Acts, some like people blame this legislation for sometimes as a barrier for our for building a new infrastructure. However, Professor Adelman arguing that most of these barriers can be overcome and they're streamlined process, and we can avoid this. So based on the data he collected, so he have more to say about how our permitting can be less costly and more timely, especially with the energy transition and climate issue that we have. So for the people who are looking for CLE credits, I'm going to show you at the end of the talk. And please remind if you have any question, we have a Q&A box. I appreciate if you post your questions while Professor Adelman present the talk. So please join me to welcome Professor David Adelman. And Professor Adelman, the floor is yours.
Okay, everyone can hear me?
Yes.
Okay, let me just share the screen here. Okay, so that's up.
Perfect.
Okay, well, thank you so much for letting me or inviting me to speak to the webinar on this webinar today. I'm going to try and do a few different things, really starting off at a relatively high level, talking about why we have such a significant sense of urgency around mitigating greenhouse gas emissions, and then just talk a little bit about kind of what that looks like in terms of the amount of deployment that's going to be required. And then I'm going to talk about some empirical work that I recently completed looking at permitting mostly of wind and solar projects, a little bit of transmission lines, and then talk a little bit about the sort of indirect effects that environmental laws have. And so I'll work through that, and I'm hoping that there'll be questions as at the end as well. I'm really looking forward to questions that people may have. So at the highest level, we've seen a lot of concern at the national level and very prominent commentators like Jerusalem Dempsis at The Atlantic, Ezra Klein at the New York Times, and then various legislators, including probably most importantly, Senator Joe Manchin when he was still in the Senate. And the perception in the national debate has been that federal environmental laws are holding up the construction of critical infrastructure, not just renewables and transmission line, but critical infrastructure generally. And these are just a few quotes of that, how environmental laws are weaponized through litigation and concerns that procedures, most importantly associated with the National Environmental Policy Act, are delaying and stalling the rapid deployment, again, particularly of renewables. This has led couple of years ago to significant amendments to the National Environmental Policy Act, referred to as NEPA. And would not be surprised if we see, efforts with the current administration and in the current Congress to promote, further amendments to NEPA and maybe statutes like the Endangered Species Act. And all around this kind of narrative that there's this significant barrier that's being generated by essentially the red tape associated with federal environmental laws. So one of the things I just want to start off with is I recognize that there's an enormous sense of urgency all around for different reasons. Certainly with regard to as the demand for electricity has been increasing, even just in the last few years, awareness of that has kicked up. And that's sort of a broad and sort of distinct constituency, and also especially among environmentalists. And this is just giving kind of a sense of the timeline we have available to stay under 1.5 degrees with regard to climate change, 1.7 and 2 degrees. And you can see we're actually 2024, the annual average global temperature was a little above 1.5. So at least in a single year, we've already reached that. Hard to know. There's going to be variability year to year. But these are like prior estimates of how many years we have to basically get to net zero if we want to stay below each of these temperatures. And in each case, we're looking at 20 to 30 years roughly. And so we really do not have very much time. Thinking about what's required to get to net zero to avoid really damaging climate change, it's sort of hard to sort of get a sense of just how much construction we have to do just focusing on the electric utility sector. And so the slides that follow are just trying to give a sense of that. So this is looking at deployments of different types of generation between 1960 and 2022. And you can see the absolute peak construction of new generation was in this relatively narrow period of time in the early 2000s, where in the largest volume of generation deployment was basically in the 40 to 60 gigawatt range. Most years it's been maybe let's say 20 to 30. And so that's just looking at the average. On the right-hand side of the slide, This is estimates of the amount of new generation that would need to be constructed under a variety of different scenarios to meet the kind of net zero. And you can see, the averages in each year are in almost all of the models substantially greater than we've done in any single year over 60-year period. So just benchmarked off of like the amount of new generation of any source of electricity that we've constructed in a year, we're going to have to go substantially beyond that. This is looking at the Princeton net zero study, and it's basically using a variety of different scenarios. The E plus is you can sort of think about a baseline scenario where you have a high level of electrification. The E minus is lower levels of electrification. The E minus B plus is with greater biomass, less electrification. The E plus and RE minus is basically placing a cap on the amount of wind and solar generation. And the E plus, RE plus is with complete reliance on renewables to decarbonize. The key thing to note here again is the amount that we have to deploy on average in these, it's broken down in 5-year chunks here, is enormous relative to the historic generation deployment levels. We actually did pretty good this past year. We had 40 gigawatts of new solar capacity and a little less than 6 gigawatts of wind. And so, excuse me, under that E plus scenario, we're actually exceeding by 2025 what we need to do. We're really lagging in wind right now. What's really holding us up, at least so far, is the solar generation deployment. The worrisome thing is that we have to accelerate the levels of deployment that we already have really pretty dramatically. And we have to do that essentially in every year between today and 2050. So it's a really hard lift, and we have to do it in every single year, basically going forward through 2050. And so that gives you a sense of why, especially people who are concerned about climate change, um, feel such urgency about doing everything we possibly can to make deployment of renewables and other decarbonization technologies as easy and quick and efficient as possible. This is just like another variation looking at that Princeton study. And basically what it's going to do is give you a sense of a visualization of that. I think it's the E plus scenario here. So it's the base scenario in their model. What it would look like to deploy the amount that we need to between now and roughly 2050. So this is starting in 2020. We're going to 2030, then 2040, and then finally 2050. So we have to build out a huge amount of transmission. Most of what you're seeing, because of the scale of wind projects, is the wind projects. But you can see it's a massive amount of development over a really large area of the country. And we have to do all of this in a relatively short period of time. So I want to start off just saying I get that, I understand that, and I feel that sense of urgency just as much as anyone else does. Oh, and this is, I guess, looking at a higher scenario. So we've got this huge sense of urgency. The question is, how are federal environmental laws factoring into it? And how much of a barrier to this rapid deployment that we require are federal environmental laws? Excuse me. So one of the things I wanted to do was put this in a little bit in context. And so the National Environmental Policy Act is basically just a procedural statute. There are 3 tiers of procedures under the statute. Their environmental impact statements are the most rigorous form of environmental review, and the form of environmental review that has received the greatest attention by Congress and by commentators generally. A weaker or quicker form of environmental review is environmental assessments, and then you have categorical exclusions, which are basically regulatory exclusions for specific classes of actions taken by the federal government that basically don't have to go through NEPA processes, and then most importantly, through environmental impact statements. What this slide is displaying is the number of EISs issued each year. So the blue are draft EISs, the orange is the final EISs, and then red is supplemental. And the key thing to observe here is that the number of, and let's just focus on final EISs, has been dropping consistently over time. And in fact, in the 1970s, the number of EISs that were being prepared in a given year was closer to 1,000. It sort of dropped down over the 1980s and the 1990s. In the 1990s, it was more like in the, I think, the 400 to 600 range. And so literally for decades, the number of EISs prepared in a given year has been continuously declining, such that we're now below 100 EISs in a given year, closer to between 80 and 90. And what that means across the entire federal government, that's the number of EISs that's prepared in a given year. And the National Environmental Policy Act, implicates literally thousands of projects in a given year. So in essence, what we've seen over time is the federal government moving away from the requirements of EISs, preparing EAs a lot more. There are different ways in which this is happening: greater use of categorical exclusions, programmatic EISs that cover, a bunch of actions below it that allow for EAs to be prepared underneath them. But we've seen this systematic decline. So at the time the same time we're seeing a lot more attention to NEPA, the form of environmental review that's been of greatest concern has actually been, declining consistently over a very, very long period of time. So that should be at least a baseline that, the federal government, for better or worse, is figuring out ways to utilize under this procedural statute more efficient procedures like environmental, or at least streamlined procedures under the statute. If you look at EISs, this is looking at the number per year for the top agencies. You can see most of the EISs are associated with the U.S. Forest Service and the Federal Highway Administration, and then the U.S. Army Corps of Engineers, which issues, most importantly, Section 404 permits for our purposes here. All of them, and especially, huge declines in the Forest Service, as well as the Federal Highway Administration. So declines across the board, declines particularly in the agencies that are preparing the most EISs across the federal government. So when we're thinking about permitting in the context, again, of wind projects, solar projects, and transmission lines, there are a relatively small number of federal environmental laws that are most important. The Endangered Species Act, the National Environmental Policy Act, which I've already been talking about, the Clean Water Act, which I just alluded to, which is Section 404 wetland permits, the Bald and Golden Eagle Protection Act, the Migratory Bird Treaty Act, and the National Historic Preservation Act. I'm going to focus here on the Endangered Species Act, NEPA, and the Clean Water Act Section 404 permitting process, which isn't to say that these other statutes aren't also really important. There are some very important changes made to the Bald and Golden Eagle Protection Act, where it now has general permits for impacts on golden eagle, well, actually just bald eagles. And I also want to say that the National Historic Preservation Act is really important here. But it was very hard, or at least so far, I haven't been able to obtain good data on compliance processes with the National Historic Preservation Act. So I'm focusing on the ESA, NEPA, and Clean Water Act because they're important, but there are other statutes out there that are also important, and we just have much less information on. Okay, so what I did was a study that looked at permitting under these three statutes between 2010 and 2021. And over that same period of time, 751 wind projects were constructed, about 66 per year, over 100 gigawatts of generation capacity. And excuse me, 1,132 solar projects, so about 94 per year, and about almost 68 gigawatts of generation capacity. So in both cases, large number of projects, really significant amount of generation capacity. And so what we can look at is the number of EISs under NEPA, so the most rigorous form of environmental review under NEPA. We can look at the number of what are referred to as standard permits under Section 404 of the Clean Water Act. So not streamlined processes, the actually individualized permitting process under the Clean Water Act. And then under the Endangered Species Act, the number of incidental take permits and habitat conservation plans required for wind and solar projects. And so here, what you can see is for wind projects, there were 26 EISs required over this time, 36 EISs for solar projects. And that amounts to a little more than 3% of the projects requiring an EIS. For Section 404 standard permits, so non-streamlined permits, 18 wind projects, 23 solar projects, right around 2% of the projects. And then for HCPs, ITPs, so permitting under the Endangered Species Act, 34 for wind projects, about 4.5% of the projects, and 6 HCPs, incidental take permits, or about 0.5% for solar projects. And so if this narrative about the impact on federal environmental laws on deployment of renewables, so here just focusing on wind and solar projects, was accurate, you'd expect at the very least to see a large percentage of the projects being subject to these most rigorous forms of environmental reviews and permitting requirements under these 3 key statutes. And we're just simply not seeing it. It's, more than 95% of the projects don't require an EIS, don't require an individualized permit under Section 404 of the Clean Water Act, and even lower percentage, particularly for solar projects, a little bit higher for wind, individualized permitting under the Endangered Species Act. And so at least the data suggest a very different relationship between federal permitting and the deployment of wind and solar projects. This is just a table with the addition. Actually, let me just move this around here. So the addition of information on litigation. So for wind projects, there were 28 cases with 28 projects that were subject to federal litigation involving a federal environmental law. For solar projects, there were 14 cases and 8 projects. Literally every single one of them was filed in California. They're all around in federal land, involved sensitive desert habitat. And then for transmission lines, 14 cases. And so remember, one of the accusations is that federal environmental laws are being weaponized against deployment of infrastructure. And again, just the volume of cases. This is a 12-year period, 28 cases, 21 projects for wind, 14 cases, 8 projects for solar. We're just not seeing a huge volume of federal litigation. And so it's hard to sustain the view that it's being federal environmental laws are being systematically weaponized against wind and solar development and even transmission lines. I was actually really surprised about the relatively small number of cases being filed against transmission lines. Sorry. Okay, so what this is looking at the number of EISs and permits under the Clean Water Act and the Endangered Species Act by state. And so it's not evenly distributed across the country. Deployment of renewables is not evenly distributed across the country as well. We see a concentration in California. that's really a combination of there's a lot of federal land there, and there's significant endangered species issues. And so that's both NEPA and the ESA. We see Florida as a little bit of a hot spot. Most of that is driven by wetlands issues associated with solar development. We actually see a significant number of cases in Hawaii that's mostly endangered species issues associated with wind projects. And then in the Midwest, you see a significant number of permitting required and environmental reviews. And that's mostly due to impacts on bat species from wind projects. So we sort of see this distribution, and we see kind of a connection between either it's specific species that are at issue, specific types of habitat, or it's often projects on federal land or in federal waters that are at issue. And I'm sorry, I thought I had updated data in this file for 2022 to 2024. And if I had those data up here, what you'd see is very similar sort of percentages. Um, if anything, we're seeing less permitting for solar projects, especially the Endangered Species Act. What we do see as a big change more recently is both litigation and permitting around offshore wind projects. And that just kind of emphasizes that where you're dealing with federal lands or federal waters, you see requirements, both NEPA requirements and permitting requirements tend to be more prevalent for those types of projects. In essence, you've got a federal nexus automatically if you're on federal land or you're in federal waters. This is looking beyond the data set of permitting. It's looking at using kind of a combination of data from the Sabin Center, which does an annual report on public opposition to renewable projects. And so we're looking at both the absolute number of projects where there was public opposition and the percentage of projects that were opposed. So you see both kind of wide variation in the number of projects that are opposed by state and the percentages, somewhat with like kind of hot spots in the Northeast, I would say. California has actually a significant number of projects that were opposed, but it also has a large number of projects. And there's some states that just have really small number of projects, but significant amounts of public opposition. The key thing to understand from this is in terms of sort of thinking about project opposition and its association with federal litigation, only about 12% of the projects that were opposed
Hit
by the
on
public
mute.
involved any kind of public opposition. So again, what we're seeing is it's not that there isn't significant and we're, if anything, seeing rising opposition to wind and solar projects and transmission lines. It's more that federal environmental laws aren't the dominant means by which projects are being opposed. At least we're certainly not seeing it in the form of litigation. Okay, so I've kind of alluded to this already. We kind of have two different regimes. Where projects are located on federal lands or waters, where public opposition is limited to challenges and where it's limited to challenges under federal environmental laws, we see both greater requirements for compliance with NEPA and with federal waters, like an offshore wind project, you almost always have some kind of wetlands issues. And so we have greater permitting as well. Um, and we see higher percentages of litigation. We're seeing that both with offshore wind and the litigation over solar development on federal lands in California and Nevada. Where you have projects on private land, most of the public opposition is at the state and local level. And the principal reason for that is that project developers systematically avoid triggering a federal nexus. So they avoid permitting under the ESA, they avoid standard permits under the Clean Water Act. If they get any kind of permitting at all, it's going to be a nationwide permit that's categorically excluded from NEPA compliance. and typically, doesn't require compliance with the ESA, or there are certain circumstances where there's some consultation that's required there too. But basically, there's not a federal nexus. And in essence, federal permitting and federal environmental reviews are not implicated. Where are the areas of concern? Basically, the southwestern deserts, where we actually have seen quite a bit of litigation, and more recently, litigation over offshore wind. Um, and the Cape Wind case is sort of a famous case that's referred to again and again. And so maybe we shouldn't be too surprised about the litigation and the issues around offshore wind. The important point is that there are kind of distinctive characteristics associated with that development. It was also a relatively one of the very first offshore wind projects. Um, it impacted an incredibly wealthy community that could litigate forever. But the vast majority of projects don't have that characteristic. They're typically on private land. um, the people who may be concerned about it don't have the same sort of deep pockets that the opponents to the Cape Wind project had. So big difference between whether you're on federal land or in federal waters, and we're sort of seeing this sort of uneven distribution of opposition utilizing federal environmental laws. The other place I'm concerned is in the Midwestern and Great Plains states with endangered species issues. The little brown bat, the tricolor bat was up for consideration for listing, and that has an enormous range across the country. And so, particularly for wind, the endangered species issues going forward could be a significant factor. And there's also the hoary bat, which has potential to be listed. Um, Unlike the little brown bat and the tricolor bat, which are their losses are mostly driven by white nose syndrome, the hoary bat actually is disproportionately impacted by wind development, and it also has a huge range across the country. And so in terms of potential conflicts between project development, infrastructure development, and federal environmental laws, I think it's more these endangered species issues where you have these really vulnerable species that have really, really large ranges across the country, and therefore could impact a huge number of projects. Okay, so one of the, you know, perfectly reasonable concerns about just looking at permitting and just looking at federal litigation is sort of a question about, well, maybe we can't see it in terms of the number of projects that are actually subject to federal environmental reviews and federal permitting. But the reason we're not seeing that many projects is if a project has to go through NEPA, it's just not going to get built. And so the attrition is on the front end. And so we're losing a huge number of projects. Um, and we just can't see it in the data that we have available to us. I think the first thing is that is a absolutely perfectly reasonable question to raise. And the simple answer is that the data that I've collected with this study can't answer it directly. What I can say is anecdotally talking to project developers, um, the folks I've talked to, they say typically insofar as they have to get permits, most of the time they just avoid them. Um, they can navigate the process pretty well. Um, this is a study that was conducted by uh, Berkeley National Lab, um, came out in, I think, January of 2024, and it basically did a survey of project developers across the country. And so there's two data sets that are provided here. One is for cancellation of projects, and the other is for delays associated with projects. And you can see, if you're familiar with development in this area at all, it's probably not going to be, none of this is going to be surprising to you. The top is local ordinances and zoning in terms of forcing project cancellation, grid interconnection, community opposition. But what you can see in both of them environmental restrictions. And I wish the language here were a little bit more precise, but basically, it looks like environmental restrictions are responsible, and again, this is just a survey, for 10 to 15% of the projects that are canceled. 10 to 50% of the cases are a significant factor with regard to project delays. And so what that suggests is, maybe it's not the case that we're losing a lot on the front end and that these data on, the actual percentage of projects that require an environmental review or a federal permit are fairly representative. Most projects aren't really all that burdened by federal environmental reviews or federal permitting. That seems to be what this survey data, and again, it was a decent sample in this case, but not a huge one. But it's at least indicative. Okay, and actually, I'm going to stop. I'm not going to go there. So, where does this put us? One thing I want to make clear is, in some ways, what's happening is, in a good sense, like for Section 404 permits, 95 plus percent are going through, insofar as they require Section 404 permit, they're going through this streamlined nationwide permitting process. And so, basically what the agency has been able to do is calibrate the permitting process to make it as efficient as possible based on the kind of significance and the nature of the impacts of project development on wetlands in that case. You could maybe tell a similar story about NEPA that, there are a lot of instances insofar as there is a federal nexus where a project can follow under a categorical exclusion, maybe solar projects more likely than wind, or an environmental assessment. And so there's a streamlined process associated with that. The ESA is a little bit more complicated, at least from my perspective, because really it ends up maybe not quite binary, but there's just a lot of work that project developers are doing in consulting with Fish and Wildlife Service personnel to avoid having to get an incidental take permit or an HCP, because those are just viewed as being so burdensome and time consuming. And so, in essence, project developers are modifying their projects to get around the statute altogether. Um, I'm not sure, in some sense, we could say, well, they're mitigating their impacts on endangered species. They're still able to construct their projects. Maybe that's the best of all possible worlds. Um, one of the problems is so much of this is just occurring in the back through informal consultations, basically voluntary consultation processes, and none of it is really all that visible. And there's not really any kind of middle ground permitting process under the Endangered Species Act like we have with a nationwide permit, or an environmental assessment under the National Environmental Policy Act. The ESA issues strike me as more complicated. And as I was alluding to earlier, I think they could get much, much more challenging going forward, especially if the tricolor bat is listed or if the hoary bat is listed. It's under those circumstances, many, many more projects are not going to be able to, or it's going to be much, much harder for them, particularly wind projects, to avoid having to get an incidental take permit and a habitat conservation plan. And you could easily imagine the agencies getting overwhelmed in those circumstances. So, and I'll just say really quickly, I think there are interesting things that the agencies are doing. They're using programmatic biological opinions, programmatic environmental impact statements, to, basically look at things at a much, much broader level and basically allow for more streamlined processes for individual projects under kind of the umbrella of those programmatic documents. I think that's a really interesting approach. I think it's sort of had mixed results so far, and maybe in the Q&A we can sort of talk about those sorts of strategies a little bit more. So I'll stop there, and I really look forward to people's questions.
Perfect. Thank you so much, Professor. I'll let you get that off of there and then so can you hear me okay?
Yeah.
Okay. So we're going to share, I believe the CLE number if you need that. So that'll be up there. But so thank you so much for this. I found this very interesting as someone who teaches energy and uh renewable energy and then also was in practice for a while is really to look at the numbers and to look at where this is happening. And one thing that was coming to mind, and multiple things came to mind, and I'd love to talk about everything, but one thing is that are we going to see, as we're needing to increase the volume, and you had on the map the number of interconnections and the amount of infrastructure and transmission that we're going to need to get where we need to be. At what point will those start creating cumulative impacts that maybe would trigger a additional review that might not have been there before? So it's one thing to have one transmission line or one project that maybe would be okay and it would have like environmental assessment instead of an environmental impact statement. But what happens when we get to the volume that we're needing? Are we going to start seeing more pushback on the cumulative impact that might create more need for greater scrutiny?
So you're specifically talking about NEPA here.
I am, yes, NEPA.
Yeah, so there are a couple of facets of that. First, you need a federal nexus in the first place, and so again, a lot of the vast majority of projects that are on private land um, avoid, at least so far, having a federal nexus. And so, at least in that context, if that's the case, that's not going to be so much of an issue. Development offshore on public lands. Um, you could imagine those sorts of issues coming up. And, so there's a recent programmatic environmental impact statement for solar development in the Western states. Um, there's the Desert Renewable Energy Conservation Plan. And so there have been efforts to look at things more comprehensively under a programmatic that I think would take into account those cumulative impacts of development over a large scale, multiple projects that might kind of interact with each other in some way. Um, so I think that could be a more significant issue over time. Um, I'm just not sure how broad that is going to be. And I think it's harder to sort of say how it's going to play out on private land. So one thing you could say is on public land, maybe programmatics can take care of it. On private land, you know, my intuition is maybe seems less likely if there's not a federal nexus. Um, it's a huge amount of development, but it's a massive country. And my just sense would be there may be places where development is of sufficient density where those become issues, but I'm not sure it's going to be so widespread. And if you sort of look at projections for where development is going to occur around the country, um, it's not all super high volume everywhere. And so it may also be sort of limited to certain areas. Texas, we've got a huge amount of, over 40 gigawatts of wind already. Texas is almost all private land. And so far, we haven't seen those sorts of issues come up.
Right. And so it made me also think when I saw the map, and we do have a question in the Q&A about Alaska and Hawaii. I know you
Mhm.
mentioned Hawaii had impacts, ESA impacts mostly. And so I don't know if you want to respond to that about potentially applicability of this in Alaska and Hawaii, given that they weren't on your map.
Yeah, actually, so it was more wetlands issues in Alaska, relatively small projects, but still there are a lot of wetlands in Alaska. So definitely more permitting issues in Alaska. Hawaii, it's just there's so many unique species in Hawaii. Um, and so particularly for wind development, definitely it will be more, the federal permitting in that context is going to be more challenging. So, you can sort of, the endangered species issues are, I think they're going to be very geographically delimited. Hawaii was a special case. I would say California is significant. And then you've got the bat species, which are not so geographically limited just because their ranges are so big.
And so we're seeing and please, anyone, please put questions in the Q&A if you would like anything answered. But so we're also seeing the new administration indicating that it, like in the one executive order, it was putting people over fish, and some of them like saying, streamlining the ESA and all of these types of regulatory measures. And so what do you think is maybe, is there potentially going to be a big change with this, do you foresee, or what do you think the impact of that will be as we kind of move through the next few years?
I mean, so there was the emergency executive order with regard to energy, and they tried to basically grant Section 404 permits for 700 projects, which included solar projects, on an emergency basis. And there's a emergency provision under the Clean Water Act. Personally, I think that was incredibly dubious, and I think the administration has stepped back from such a blanket approval process. Um, are they going to be willing to go through permitting processes in a more abridged, less careful way? That certainly seems likely to me. Um, I don't personally don't view that as a good thing. Um, I mean, I suppose the one positive thing you could say is, although, I mean, for example, under Section 404, there's public processes that you have to go through just to issue a standard permit. Um, and unless you sort of try to bring it under these emergency provisions, you really can't get around those. Um, I guess the bottom line is I don't think the strategy is going to work. The Center for Biological Diversity has already said it's going to sue. I doubt that it would hold up in court, at least at that level. Um, could you see some legislative changes? Maybe that's like, the bigger potential issue. But the House is really, really close. The Senate is really, really close. I think predicting that is, and how much of a priority it's going to be legislatively, I think all of that is still kind of murky and uncertain.
It definitely is. And I wonder also if it's going to have an impact on states implementing more SEPA, so state reviews. And you might want to tell everybody a little bit. I don't know if you did any kind of analysis on what impact the state SEPA could have and has had, because California has its
Sequel.
own, um,
The CEQA process.
Yeah.
yeah. And so it might be interesting to see how that might change things or.
Yeah, I mean, I haven't done any, I mean, I know generally a little bit about CEQA in California. One of the key differences between, and this is not always appreciated, is, for NEPA to apply, there has to be some kind of federal nexus. So federal land, federal money, some kind of federal permit. CEQA, that's not the case. And so this, difference between public and private land that we observe at the federal level does not apply, within California. And I'm less familiar with the other states and their statutes. I think CEQA is sort of at the high end in terms of its requirements and applicability and the litigation under it. But I think it's an interesting case. Will states step in require greater environmental reviews through their own statutes, and that could sort of offset any kind of efforts of the current administration to, loosen enforcement of particularly the National Environmental Policy Act.
Yeah, and so we have a question in the Q&A, and it's you can let me know if this is something that you could speak to, but do you think that the tax credits in the Inflation Reduction Act have a noticeable impact on public opinion toward solar and wind projects? And maybe this NIMBYism generally of if you can't speak to that directly, but yeah.
Um, you mean in terms of like the sense that the wind and solar projects are getting this big government giveaway, and that sort of maybe makes people feel more negatively towards wind and solar development?
I guess, I mean, the question
And
could be either more negatively or more positively.
yeah, I mean, I would say, like Texas has been a huge beneficiary of federal incentives, like there's a huge amount of economic development and investment in the state that is significantly driven by the tax credits. I think that, part of the dynamic that's going on with local communities is um, beyond the landowners who are benefiting from leases or royalties from solar and wind development, the local communities feel impacted. A lot of it is sort of, it's complicated, the politics around it, but a lot of it seems to be impact on viewshed and aesthetic considerations. Um, and what I see project developers doing, and certainly the tax credits enable them to do this, is just be more generous towards the local communities. So, for example, solar projects in California get 100% abatement of local taxes, but project developers will often enter into community benefits agreements that are quite significant. So it's not, basically it's almost like a form of revenue sharing that they're agreeing to. And so I think that tax credits definitely give them some flexibility to do that, and that can mitigate local opposition.
What are the common elements that you're seeing across these community benefits agreements? Success.
So, standard ones are job training and certain numbers of jobs. You see this like for any kind of economic development. Um, Often minimum annual payments that will be on a megawatt basis that the projects will provide to the local community. Sometimes they'll set up separate funds that they just provide up front that, the community has broad discretion in how they utilize it. Sometimes it's just agreeing to pay for certain upgrades or, like some addition to a hospital or something like that. They really occur in a lot of different forms and mostly on an ad hoc basis. I think, talking to different project developers, I think there's just a lot more attention to community benefits agreements, and I think an interest in establishing some norms around them and establishing norms around local taxation as well, which is just really highly variable and oftentimes a source of uncertainty too.
Yeah, really interesting. I don't know if Carmen, if you have any questions, I don't want to hog it all. I have
Yeah,
more,
I have
but you
one
might have one
question.
you would like to ask.
So you didn't cover like carbon capture and storage projects, but I'm wondering because recently, even many like just 2 weeks ago, the business community asked the EPA administrator to like grant the Texas the primacy to a
Yeah.
class six. And I looked to the data, like we have around 161 application for class six, and one third are located in Texas.
Mhm.
And if you look to the the duration. Like most of them, they are waiting for over 2 years. So I know that primacy like accelerated the process, but I'm wondering like what do you think about that? Is there any like, for example, we can argue that in terms of carbon capture, definitely our environmental regulation can be seen a barrier of example for developing, which is arguably most of the businesses saying that.
Yeah, I mean, there's also like Louisiana, I think recently got primacy.
Yes.
Um,
So we have three states like Wyoming, North Dakota, and Louisiana. So Texas will be the fourth if we
yeah.
get primacy.
So I'm less familiar with those regulations. It's been a while since I looked at it. You know, I guess I've heard a lot of criticism of them. Um, both the cost and kind of the scale of the review area that's required for a sequestration site, as well as the processing times. Um, and, um, I think it's anytime you've got a relatively new, in this case, technology and you're developing a complex environment, just historically, it takes a while for an agency to refine its regulatory program. And because there have been relatively few sequestration sites approved, we're still early in that process. And so, I think the one caution I would just say is, you know, you could look at this across any of the major federal environmental statutes. Those first few years and those first number of projects that are approved, just like any kind of learning, there's a learning curve and efficiencies and experience that are gained over time. And I think we're still, you know, it's been a number of years, but I think we're still, you know, working our way up that learning curve. And then um, I think, the worry that you don't want something to go wrong, even though I think it's personally, I view it as a very safe form of mitigating carbon emissions. Um, a special kind of risk aversion, especially when we're still have a relatively small number of projects that have been developed.
I feel like that's part of the issue with offshore wind as
Yeah,
well, right? It suffers from the same issue of still being quite new
yeah,
and concerns about the types of potentially negative impacts it can have. Um,
yeah, I
and
agree very much. I think there's been a lot of learning in the agencies just over the Biden administration. And I think there was a sense that um, they were getting much, much more efficient um, in processing the applications. But we'll also see this is where the current administration could really disrupt that process, unfortunately.
yeah. Yeah, we're all waiting to see what the result of some of it is going to be. And
Yeah,
but we have 1 minute left, and so I think that we're probably in a great position to say thank you so much for your time and what a great paper. And we will post everything, right? We'll post the video and we'll post the slides, and everyone can have access to those. So we greatly appreciate it, and thank you for all for joining us today.
yeah. Thank you. I really enjoyed it.